No.
Of course it is.
No, you're making an inference on my silence. Only a court and a jury are allowed to do that. Your role...
This is the exact moment the encounter goes wrong. Inside a public government building, a private citizen is lawfully recording public information. But instead of identifying any legal restriction, the officer asks a question with no basis in UK law. Why do you need to film? In the UK, rights don't depend on motive. Article 10 protects the recording of information unless a specific lawful power says otherwise, and none exists here. From this point on, the officer isn't enforcing law. They're testing whether a right can be questioned away. And once that happens, escalation is unavoidable.
What is that for?
Pardon?
What purpose is that for?
To have a look at it, but it's public information from...
It is, but why you then feel the need to film it? If you want to read it, then that's one thing, but why do you feel the need to film it?
Because my memory is not that great.
Okay.
So, I can't remember everything that I see on every single board in here, can I?
Okay. Do you have a job?
Pardon?
Do you have a job?
Is that relevant?
Well, yeah, because you're in a job centre, aren't you?
Right.
Are you seeking employment?
Is that any of your business right now?
Well, yeah, because you're in a job centre, aren't
Right,
you?
that's not your business, that's my business.
But I'm just trying to understand the purpose of why you need to read that information, why you need to retain that information.
Because I have the right to do so,
You do, but I'm
Constable.
just trying to understand.
Yeah, but that's all you need to know, though, isn't it? Because I have the right to do so. I'm in a public place, it's public information. I have the right to freedom of expression, which includes gathering and disseminating information and opinions to others.
Right.
So, therefore, that's all
what
you
is
need to
your
know.
intention to do
Because
with
you
this video?
swore an oath to uphold the rights and freedoms of the people. You swore an oath to the crown of this country.
Yeah.
So that's all you need to know, is that
what
I'm acting within a right, a freedom.
Okay.
I'm not doing anything unlawful. So that's all you need to know, and that's all you need to tell them.
Here, the justification shifts from curiosity to safeguarding, but the legal problem deepens. Data protection and privacy concerns inside a job center fall under civil regulation and the Information Commissioner's Office, not police enforcement. Police powers are engaged only where a criminal offense is suspected, and filming members of the public in a public-facing area is not by itself a crime. Crucially, potential discomfort or vulnerability does not create police powers where none exist. Safeguarding obligations sit with the premises operator, not with officers improvising restrictions. By continuing to question the filmer's intentions, the officer blurs the line between policy preference and lawful authority. That confusion is procedural, not emotional, and it places the officer on legally unstable ground.
Yes, I have, and that's your job done then, isn't it, I'm afraid?
What is your intention to do with the video, though?
But again, that's none of your business.
Well, it is, because if it captures other people, like members of the public who are coming in here, who don't want their face shown anywhere, we might have people who are going through horrendous things at the minute or involved in domestic violence, and they don't want other people to see that they're in this job centre on this particular day in Lincoln, because then other people will know where they are. Then that's safeguarding them, isn't it?
Then they would need to contact the Information Commissioner's Office because it's their jurisdiction, not the police.
Yes, but if you're not
No, simple as that, ends there.
If you're not telling me where you're going to upload this...
Who said I'm uploading it? I said it's none of your business what I'm doing with it.
You're not telling me then, aren't
Because I don't need to answer your questions. I don't need to account for a lawful action. Right, and I don't need to account for an action unless you have evidence or reasonable suspicion. It has to be based on objective fact.
Yeah.
This exchange exposes a subtle but serious procedural issue. UK policing operates on reasonable suspicion based on objective facts, not assumptions drawn from silence. A person's refusal to answer questions or explain lawful conduct cannot, in law, be treated as evidence of wrongdoing. Only a court may draw adverse inferences, and only in strictly defined circumstances. When an officer suggests that silence is not helping yourself, it risks implying that cooperation is mandatory, which it is not. The legal test is simple. Without evidence of a crime, police engagement must remain consensual. At this point, the officer is no longer investigating facts, they are testing compliance. That distinction matters because it defines whether an interaction is lawful or drifting into coercion.
Of course it is.
No, you're making an inference on my silence. Only a court and a jury are allowed to do that.
No.
Your role is to work on the facts that you know based on objective facts, not on, I think he might be doing
It's
this.
evidence that's
Is it?
there for me.
Is it? What evidence is that?
Well, this is for me to make my decision in relation to what's going to happen. I've asked you what you're going to do with it. You've refused point blank to tell me.
Because I don't have to answer your
Because you
questions.
don't have to answer, because you're being quite
Correct. Because I'm exercising my rights.
Well, I find it obstructive.
I'm upset because I'm exercising my rights. It's my right not to talk
It
to
is,
you.
but then you're not really helping yourself, are you? Because you're refusing to engage.
So you're implying that a member of the public who doesn't want to talk to the police and account for their actions is inherently damning themselves?
I find you quite goading. I think you're goading for an argument, and I think that's.
I would be quite happy if you came in, said hello, yeah, you're filming, bye, and walked away. I would have been quite happy with that. You're the one who's continuing to stand here and talk.
This moment represents the peak of escalation. The act of continuing to film is characterized as a threat, despite remaining lawful. UK law is clear. Filming in a public place or a public-facing area where access has not been lawfully withdrawn does not become criminal because it is persistent or uncomfortable. Trespass, even if it were established, is a civil matter unless aggravated by additional criminal conduct. Police powers do not expand simply because staff feel pressured or challenged. At this stage, officers must either identify a specific offense or disengage. And that is exactly where the law draws the line. Not at inconvenience, not at disagreement, but at legality.
I just want to say, I want to make a fair compromise with you. All I want is to go get a picture of that board 3.
If you're going to take a picture without recording, as we said before, you're more than welcome to do that.
If you don't allow me access, I'm going to stand here and I'm going to film everybody's appointment from the public place. I can see all these screens here. I can see all those screens there when I'm sat there. Pardon?
Are you threatening us?
Not threatening you, no.
You sounded like you were threatening us.
No, not at all.
And please stop recording me as well.
No, sir.
Okay, go on, take a seat then, please. So you're welcome to sit there. You're welcome in this